A landmark case is underway in front of Michigan's highest court. Attorney General Dana Nessel and the Michigan Department of Civil Rights want to add more protections to the state's civil rights law. The Elliott-Larsen Civil Rights Act protects Michiganders from discrimination based on physical characteristics or identities like religion, race, or sex. 13 on your side's Justin Bachman joins us now from the newsroom. And Justin, does the Attorney General want to add a new category or expand one of the existing ones?
Good evening, Juliet. AG Nessel and her team want to give a broader definition to the last category that you mentioned, sex. More specifically, they want it written into law that discrimination based on sexual orientation or gender identity is illegal.
It has been 46 very long years since Elliott-Larsen was passed.
Every Michigander became a little bit safer in 1976.
The predominantly white male legislature in 1976 didn't say, oh my God, we need a law that'll better protect white men.
What they did say is that discrimination had no place in things like housing, education, hiring, and much more.
That was intended to include as many people as possible. And so we're hoping that when this decision comes down, it's going to include a whole lot more people under its protection.
The original law only has the word sex as it's written. Michigan's Attorney General says it's time to expand that word's meaning. Her opposition says the law is clear in what it states.
The primary arguments that were made was that, they didn't expressly define sex as sexual orientation. And that's not what the legislature intended.
Nessel was reminded how crucial these protections are following the weekend same-sex marriage was legalized.
And many of those people called me on Monday morning because they walked into work and they tried to, register their newly recognized spouse and sign them up for healthcare benefits, and they got fired on the spot.
She says just like any other protected identity, LGBTQ plus Michiganders deserve the shield provided by Larsen.
So if you allow a Christian to be employed by your company and you allow a Jewish person to be employed by your company, you can't say, well, I don't like that you converted. I don't like that you're a Christian who became a Jew or a Jew became a Christian. Same thing with men and women.
We reached out to the attorney for both plaintiffs in the case, but we did not hear back. What we do have are court filings. The attorney for Rauch World, a wedding venue that declined to host and participate in a same-sex wedding ceremony because it conflicted with their religious beliefs, well, they claim that the Department of Civil Rights does not have the jurisdiction nor the authority to change the law or amend the definition of the word sex.
Thank you, Justin. Once again, the Elliott-Larsen Civil Rights Act did go into effect in the 1970s. It is named after the bill's two sponsors. Daisy Elliott was a Democrat from Detroit. Mel Larsen served as a Republican from Oxford. The legislature passed the bill back in 1976, and Governor William Milliken signed it into law the following year.